This channel does not promote any violence, harmful or illegal activities. All content provided by this channel is meant for educational purpose only.
2010 8 SCC.
Yes. Notes. Next, Millard. Now I cite Millard 2010. Yeah, Supreme Court Weekly 1852. আজকে we can see.
না না নোটস কয়েকটা ছিল
Yeah, Supreme Court Weekly 1852.
আচ্ছা
Kindly come to paragraph 20. In view of the above, Margot,
yes
in view of the above, the law can be summarized that the High Court has the power to initiate the contempt proceedings suo motu for ensuring compliance of the order passed by the court. However, contempt proceeding being quasi-criminal in nature, the same standard of proof is required in the same manner as in other criminal case. The alleged contender is entitled to the protection of all safeguards, rights which are provided in the criminal jurisprudence, including the benefit of doubt. There must be a clear-cut case of obstruction of administration of justice by a party intentionally to bring the matter within the ambit of the said provision. The specific charge has to be framed in precision. The alleged contender may ask the court to permit him to cross-examine the witnesses, that is, the deponents of affidavits who have deposed against him, in spite of the fact the contempt proceedings are quasi-criminal in nature. Provisions of Code of Criminal Procedure 1975 so and so evidence are not attracted for the reason that proceedings have to be concluded expeditious. Thus, the trial has to be concluded as early as possible. The case should not rest only on the allegations against the alleged contender. The proceedings must be concluded giving strict adherence to the statutory rules framed thereunder. Quasi-criminal character, criminal, like a criminal trial, charges have to be proved. Specific charges have to be made, which has not been made. Just affidavits have been given to us. And Millard, all the, my humble submission is paragraph 22, 20, what are the ingredients for coming? All are absent here. Just once Millard, I take your lordship, the charges, allegations against me, charges have not been framed, allegations. Kindly come to my lord, just. That paragraph. Paragraph 7 of the affidavit in our case, filed by these persons. Paragraph 7. TRL CP 7. Seven. Evidence set. PS, PS. That 7. That after that one Kunal Ghosh, spokesperson of ruling party of the West Bengal, organized a press conference with above mentioned
Yes.
persons and others tried to prejudice and or interferes or tenders to interfere with the due course of judicial proceeding. Said Kunal Ghosh also tends to interfere with the administration of justice and also tends to obstruct the administration of justice in several manners. He has failed to show respect towards this person. Well, this is a charge. Very vaguely, this has.
Mr. Banerjee, the conference was held, this press conference during the continuance of that agitation.
No.
Subsequent.
Long after. That during the agitation, I have pressed to your lordship, he was busy in another one channel that they sent a message. WhatsApp was sent. He said that I am busy in the interview. I placed it.
That was a different interview.
No. When the let me take it.
Yes, we remember that.
That is
That was a
that's
separate
complete
thing.
different interview. That is a news channel 18.
Right.
Complete different interview. That political persons goes that that's a complete different interview.
Very.
Nothing with this.
Right.
Well, although the earlier Act 65B certificate is required, that is not also there here. Anyway, but I am not disputing this. Whatever the interview I have given, I have already shown to your lordship. That in my affidavit I have referred to this. It has nothing to do with this. And not a single time this learned judge name has been referred. If that is so, another contempt proceeding would be initiated against one of the senior advocates. I do not want to say this. I do not want to place it. He has justified. I have seen yesterday, very recent, why this, although this is appearing in this matter, out of sheer frustration, judge is not will hear the matter. So what the litigant will do? Sheer frustration, his frustration and client's frustration. I am not going there, but and regarding the one thing I have to say, that's part of this institution. I am just saying, not the Kunal Ghosh. I am saying part of this institution. I am just, these posters, banners, etc. of the judges were not earlier. That was not the culture of the Calcutta High Court. That was never done. First time it has come, when one of your lordship's ex-colleague, his poster was there behind the rickshaw. Tumi Bhagavan. One after another rickshaw, another poster, his poster, advertisement of the sari as dhuti and kuttas. Who has brought this dignity? This culture was not there at all Calcutta High Court. I am very nice. The Honorable Chief Justice on his at his suo motu has taken cognizance in this matter, although not permissible. Why the Chief Justice did not take cognizance earlier, suo motu? When is one of the brother judges committing a breach of the dignity of the High Court judiciary? These questions are also there. In an administrative side, why did he not do? Why the 1997? Even a petition was filed in 1997, the code of conduct which has been followed by the collegiums of this by the Supreme Court, code of conduct of the judges wanted to implement this Honorable Chief Justice in judicial side, dismiss the petition, press conference, etc. Why? Sitting judge, sitting matter, taking a matter, giving a press conference. Who has brought the dignity at the end? When the question of dignity will come, dignity of everybody will raise it. Again, I have said it, your lordships will be here for 10 years or 12 years. My Lord Justice Banerjee will be here for another 6 months or 7 months in Calcutta High Court, then we'll go somewhere. Justice Bhattacharya will also be there 5 or 6 or 7 years, then we'll go to another places.
Let us be on facts,
Onward, I am coming.
not on surmise.
No, no, sir, that will be done. That will be happen. Now, we will be here. We are more concerned about the dignity of this court and justice, judges. Now, anyway, I have nothing to collect with this. And what we, the police report, kindly see this. Police report given me. Not surmises, these are all calculations. And somewhere, some places, some
Only one person decides.
justice, very nicely I said. Very recently, I had just a thing. Joint parliamentary committee, the two, Justice Care and Justice Chandrachur appeared there. The Justice Care has started making this statement. Going nowhere. Later I came, after his submission, I came out and I said, how are you, sir? Why you are, how I have done, like a lawyer. And still you feel that there should be a lawyer. Yes, lawyer's life is the best life. And why didn't you have chosen there? Why have chosen? Destiny. That's the destiny. Destiny is this everything. Now, kindly come to me, report. Report of the police commissioner report. Report was short from the police. But I am not required to read. Kindly note that one sentence. Note that one sentence. That will be enough. Kindly, I have read. Nothing has been said against my client in that report. Nothing has been.
No, we'll have to.
Nothing has been said against my client. Kindly see to that. Huh? 17th May 2025. Nothing has been said against my client. It will take long time. Nothing has been said against my client in that. Now, two judgments I will finish. This.
আমি করেই রাখুন, সিল করতে হবে না।
These parts, all merits, etc., maintainability of the petitions, quasi judicial, etc., all that things I have dealt with, I am not going to say. Now, ultimately, let's come to the point. Ultimately, even if your lordships are not satisfied with my answer, whatever the submissions I have made, ultimately, I have expressed my apology. Without any if or but, straight, I have said so. But how your lordships will deal with such a situation? But 2016, 9 SCC, paragraph 9 to 11. বললাম তো একবার শুনিস না কান দিয়ে 2009 page 543 343 sorry 343 paragraph 9 to 11. After hearing the learned counsel for the parties, we inquired from Mr. Sibbal and Mr. Singhvi understanding of whether the petitioner is present in court, and their answer was in the affirmative. Be it stated, Mr. Rabal was absolutely clear of the proclivity exposed by the petitioner, as he has been indulging and giving interview to the electronic media regarding had to the same. We wanted the petitioner, Yathan Swanso, who is present in court, to file an affidavit. The affidavit that has been filed today, in addition to the affidavit that has already been filed on 25th, also reiterated that he tenders unconditional apology and undertakes that shall not speak on the subject in issue in public except in court's proceeding. On further hearing, it has been clarified that he will not speak to the print media nor give any kind of interview or speak to the Swanso. 11. Centuries ago, the famous speaker of Greece, Demosthenes, had said, articulation has to be sincere and honest. we treat that apology submitted by Mr. So-and-so who is present and filed the affidavit to be articulately sincere, and accordingly we exonerate him. Needless to say, if the petitioner will speak in the tenor he has spoken, that may tantamount to expressive contempt of the court. Another one, Judgment Miller. 1996 6 SCC. Huh? Good. 1996 6 SCC, page 466. 466. Paragraph 12, my lord. Paragraph 12. Paragraph 12. But it, my lord, got it. But it may be pointed out that various judgments and pronouncements of this court bear testimony to the fact that this court is not hypersensitive in matters relating to contempt of court and had always shown magnanimity in accepting the apology on being satisfied that the errors made in the publication was without any malice or without any intention of disrespect towards the court or towards any member of the judiciary. This court has always entertained fair criticism of the judgments and orders of about the persons of a judge. For criticism within the parameters of law is always welcome in a democratic system, but the news items which are concerned can neither be said to be fair or made in good faith, but which wholly false, and the explanation given in far from satisfactory is so and so tell the as well as Vijay Kumar Chopra, editor and publisher of the Daily Punjab Kesari, taken the stand that they had taken the news items to be correct on the basis of the information supplied by a very senior journalist of long standing, so and so, but this cannot be accepted as a valid excuse. It may be stated that at common law, absence of intention of knowledge about the correctness of the contents of the matter published, for example, as in the present case on the basis of information received from the journalist report, will be no avail for the editors and publishers for contempt of court, but determining the quantum of punishment which may be awarded. Thus, they cannot escape the responsibility for being careless in publishing is without caring to verify the correctness. However, since they have not only expressed repentance on the incidents, but have expressed their sincere written unconditional apology, we accept the same with the warning that they should be very careful in future as regards the case of Dinar. So, similar, this is why I always. I am a member of the privilege committee. I tell you, privilege committee, and I am the possibly I am the longest 5 years here, 26, 17 years privilege committee, and it's a quasi judicial body, absolutely quasi judicial, and decides whether there's a breach of privilege or etc. 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 There are cases of whoever comes chairman, they take my. Ultimately, is this if someone is sincerely seek an apology, all right, go. Not ethics. I am talking of privilege. Ethics is different. Privilege is different. আর কি আছে আর দেখাবো না Sri Dinanath Mishra has no doubt committed a serious mistake, but he has realized his mistake and expressed sincere repentance and has tendered unconditional. But Dorkan, it's all right. That, my lord, here I have nothing to do. Even then, I have said. Now, my lord, kindly come to the rule which has been issued. Rule.
জলপাইগুড়ি ফিরছে হচ্ছে 3 তারিখে,
রুলটা দাও।
3rd অগস্ট। 3rd অগস্ট হচ্ছে রোববার। 21 থেকে 3rd আমি থাকছি। হ্যাঁ হ্যাঁ,
রুল যেটা সার্ভিস হচ্ছে, অর্ডার না, রুল which has been served upon us.
হ্যাঁ হ্যাঁ, যখন তুমি 4:30। সাড়ে বারোটা থেকে মানে শুধু ফার্স্ট হাফটাই রাখবো, সেটা ক্ল্যারিফাই করবে। কারণ সেখানে সারাদিন চালাবে, 4:30 এই শেষ করবো। বাকি তো পার্থদা আছে, আটকাবে কি এই একরকম আর স্পেসিফিক করে যে 12:30 কিছু আছে।
ওখানে পাবেন না। আরে হাইকোর্ট থেকে যে রুলটা ইস্যু করেছে, ওই দেখা দেখান আমাকে। আর না না ওটা না,
রুলটা রুলের ফর্মে থাকবে, যেরকম রুলের, হ্যাঁ ওটা দেখি, ওটা দেখি, এই একটা ইয়ে করে থাকবে। না না এটা না,
তুমি তো জানো রুল।
দ্যাট ইজ নট দি রুল।
অনিন্দিতা যেটা রুলের ফরম্যাটে থাকে না, যেটা
রুলের ফরম্যাটটা, আরে না রে ভাই
format
ওটা নয়। কাইন্ডলি টেক দিস ওয়ান।
না, আচ্ছা এটা হলেও চলবে। হ্যাঁ হ্যাঁ, এইটা ইয়ে অরিজিৎ দা,
এটা কুনাল ঘোষেরটা না, এই ফলে কুনাল ঘোষেরটা নয়, এটা অন্যরা।
ও
না একটু কুনাল।
কোনাল কোনাল এটাই। তুমি রাখো তো,
Yes, this is the one.
একটা আমাকে দিয়ে
Did
দেবে।
this to Kunal Ghosh residing at 1/1 Rammohn Rai Road, alleged container number 8, rule in the form HC form number 2. HC form number 2.
এটা rule. This is the rule, Mr. Banerjee.
Anyway,
বন্দ্যোপাধ্যায়।
thanks.
This is the format in which it is sent.
This is.
পেয়েছিস তুই?
হ্যাঁ
Can I read, Miller?
পেয়েছি।
হ্যাঁ ওটাই ওটাই।
Whereas it has been brought to the notice of this court by Mrs. Tisha mentioned in the affidavit, Ghosh, law student, that the alleged container number 1 to 8 unlawfully assembled and committed the acts of.
It's not tallying, Mr. বন্দ্যোপাধ্যায়.
Therefore, it's not.
Not tallying.
Served with us.
7.
It says whereas it has been reported by Mr. Amitabh Ghosh, learned advocate, that
No.
you
Kindly
Rajraj.
check this.
ইয়ে দিচ্ছি।
It has been served upon us. Our copy আছে?
7.
Kindly just see.
This is not the rule, Mr.
This has been served upon us. Rule. Summons.
This is the rule at the end.
Oh.
At the end.
আমার কাছে যেটা আছে সেটা অন্য দেখতে, রাজু দাস ফাজু দাস, কিন্তু ফরম্যাটটা একই হবে।
জজ সাহেব এটা বলছেন।
This is the rule. এটা দাও নাকি? ওই যেটা দিয়েছিলে।
জজ সাহেব বলছে লাস্টে কি একটা আছে দেখি।
হ্যাঁ এটাই।
Yes. Now kindly similar. First is that this has ordered the rule.
হ্যাঁ ত্রিশা গুহ ওটাই।
Kindly see the rule is this one, my lord.
ত্রিশা গুহ, yes, we got it.
No, rule is this one.
No, Mr. বন্দ্যোপাধ্যায়. This is the rule in our format.
Let me read it. Whereas it, which has been served, whereas it has been brought to the notice of this court by Mrs. Tisha so Ghosh, law student, that the alleged container numbers 1 to 8 unlawful assembled and committed the acts of obstruction of justice, intimidation of advocates, scandalization of the court, and interference with the administration of justice on 25th April 2025 at 10 Kiran Shankar Rai Road, Kolkata 7,01,000, thereby lowered, belittled the majesty, prestige, and dignity of this court, and uttered derogatory, scurrilous remarks of any concerning an honorable judge of this court, with an intent to scandalize this honorable court, lower the authority in the eyes of the public, and eroding the public confidence in the judicial institution, thereby constituting grave and deliberate act of criminal contempt. It is thus ordered that a rule do issue, calling upon the alleged container number 1 to 8 to so cause why they should not be committed to prison or otherwise penalized or dealt with for the acts and conducts as stated above. The rule is made returnable on 16 June 2000.
এই এটা কি? এটা কেন ডিফারেন্ট কেন? পুরো, কিন্তু আমি বলছি এই যে আমাদের ফরম্যাটে রুল হয়, এটাই তো আমরা রুল সই করি।
The problem is, my lord, your lordship is looking into Your lordship is looking into form number 1,
Yes.
but it is form number 2, suo moto. The form number 2.
But substantially it is the same.
Anyway,
Substantially it is the same.
not. Now what is the charge? Charge here that my client was assembled here also. And that is far from the fact. Far from the fact. I mean, I will be submitting this has been done for a political purpose. I have said already that these advocates whose names are there, they are not pure advocates, simple advocates. They are also politicians and completely of the opposite parties. CPM. Completely opposition. And I am the spokesperson of the ruling party. That's the reason I have brought it. Any of the single charges, whatever they are, that is not established in my case. Right from, I will not repeat whatever I have said.
That is all.
That's all my submission. I am grateful to your losses that your losses have given me
When is your
very fair opportunity of hearing. Very fair opportunity of hearing your losses have given us.
when is your flight to Delhi? You were looking at your watch. 6 o'clock.
Time is there. 4:30. If I leave 4:30, even 5:15, I'll reach 6 o'clock.
Any other?
Tiring. Very tiring. Life has become very tiring.
Can I ask a personal question,
Yes,
Mr. Andhwata? You do not look more than 40 to 50.
But I am approaching 70. Approaching 70.
God is kind.
And every day I work at least 16 hours, 17 hours, 18 hours. And 24/7, not Saturday, Sunday I have. Not Saturday, Sunday. Saturday, Sunday is a just nightmare to me. Friday, up to Friday it is all right. After Friday, tomorrow is Saturday, day after tomorrow is Sunday. Nightmare to me. After Sunday is crossed, if I get, I can say, if I get a Sunday this afternoon, I mean, if I can come back to my home and take rice and meat and get a sleep for 2 hours, that is the rest of my whole week. Bangalir মাংস ভাত রবিবারে. It is so enjoyable to me. And sometimes, and I need sometimes Friday evening I get with my granddaughters and grandsons. These are my they are my oxygen now.
MB is the Mangsho Bhat, MB, and BG is the Bhat Khum.
BG is Bhat Khum, and that Lord is on Friday.
Yes. Any other learned advocate?
So deeply obliged, very nice.
Thank you.
Thank
you. Any other learned advocate for the alleged?
Long days I have appeared before Justice
Yes.
Bhattacharya.
It's a pleasure, Mr. Banerjee.
It is always pleasure. Very nice. Nice bench. Nice bench. Fantastic.
Have you noticed?
Sometimes lawyers get these types of chances.
Have you noticed B cube? Bhattacharya, Bharatwaj, Banerjee.
Telling that simply all you are 3. Fortunately, I have come. Make it 4.
Yes.
Otherwise,
Combination.
no jatra. No jatra. Deep love this.
Anybody else for the alleged contemners?
The ILS.
No. We will hear the petitioners and whoever is supporting the contempt application later, but the contemners?
You are for 1 to 7.
1 to 7.
Rest of the
1 to 7 in CR 5.
ওরা বোধহয় সবকটাতেই কম।
আচ্ছা আচ্ছা
এটা সুন্দর দেখতে। ফুল নেমটা জিজ্ঞেস করবো। Sorry, we have what is a full name? We have forgotten your son.
প্রতীক মজুমদার।
Mojumdar.
হ্যাঁ
প্রতীক।
প্রতীক। উনি 1 to 7 এর জন্য
CRLCP 5
1 to 3 আলাদা করেছে আর ওরা you have filed separate affidavits 1 to 3 and
yes
but the content must be similar, exactly similar, or
yes
is there some difference?
CRLCP 5 I
Have you
appear
filed
for-
your affidavits in 7 also? Because you are on that.
yes except Mr. Kunal Ghosh I am appearing for the remaining
Yes, right. So your stand must be the same in all the affidavits.
Millet,
Tribunal
may-
কি পাবে না?
before Mr. Majumdar Millet starts, Millet, I believe Millet what he is relying upon has not been served on CRLCP 7. I represent CRLCP 7, where Millet, I have not received the copy of
Why did you
Millet.
point out at the outset?
Millet,
Should have pointed out at the outset so we could.
doesn't matter, Millet. Let him place it, Millet.
it will be served
Let him
Yes,
place
yes,
it, and
yes,
after that
yes,
he
yes.
can. I'm just putting it on notice, Millet, because I have to reply to Mr. Banerjee because that's my application, but I'm like maintainability point.
Yes.
so as far as the maintainability of this suo motu contempt proceeding is concerned I am adopting the submissions made by my learned senior Mr. Bandyopadhyay. I will not be making any submission on that. In the affidavit as well as today, I have only one submission, that is apology, nothing more than that. Because some things, these unfortunate events, দিচ্ছি।
হুম
আর তো এই ক্ষেত্রে তো কল্যাণ স্যার ছিল।
না, এটা কমপ্লেন্ট এগুলো অপোজিশন না। হ্যাঁ 1 to 7 1 to 7 to 8
ঠিক আছে এইটাতেও হবে
ওর অ্যাপোলজি দিয়েছে বলছে ফ্রাস্ট্রেশন সার্ভিসের বাজেট ঠিক হবে না। Frustration, verge of starvation. 1 to 7 এর অপশনটা পেয়েছি। 1 to 7 অপশন CR 7 এ যেটা আছে সেটা পেয়েছি। ও কি সময় নেবে ও তো ওখানে জলপাইগুড়িতে সব মিস করবো। জামিরকে দেখতে পাবো না, এরকম একটা হেলো পোর্টালে আসছে সারা জীবন অপেক্ষা করে জামিরকে প্রথম নামটা খুব ডাইসি। না ওটা ওই ইয়ের মতো চোকালিঙ্গামের মতো। অর্থাৎ একটা এদিকে চয়ের লয়ের দোষে
of Mr. Bandyopadhyay. And at the outset, your lordship, my client tenders their unconditional apology. So whatever the incident that has happened, it's a very unfortunate incident. should not have been happened. I will not justify that incident because there are some things which cannot be justified and ought not to be justified. As an officer of the court, I should not justify. But whatever happened, I can tell you, Rashi, one thing that has, I will not say frustration, but what has happened is a circumstance. They are victims of this circumstance. They have been agitating for the past 4 years, 5 years. They are waiting because they are recommended candidates. They all are recommended candidates, and because of an interim order, the entire selection process has been stalled. So obviously, they were expecting that the matter will be heard out, and when the state was ready to give appointment, they were expecting that something positive might come out. But because of this interim order and everything, because of several adjournments that were granted, that is the only thing which might have triggered everything. Alosh. Out of it can be out of frustration, it can be out of some can I say some completely out of frustration. They are the circumstances beyond their control, Your Lordship. They are financially insecure, they are mentally insecure, they have families, and I can assure Your Lordship one thing, it was never their intention to dishonor or malign this honorable institution. They were organizing a peaceful protest, that is all. The allegations that has been given against my client of stampeding or stepping upon the picture of an honorable judge, I completely deny that. Because none of them either have brought the pictures or they were even near when this incident happened.
But while arguing, Mr. Bandyopadhyay had cited pictures, photographs. From those photographs, while he was seeking to argue that some of the counsel for your other sides, they are political persons and all, and they had been holding press conferences with the same persons. While saying so, he placed reliance on certain photographs which show that at least the first contender was present in all these pictures. So therefore, isn't that a tacit admission?
Not an admission. With all due respect, Your Lordship, that is not an admission.
We have photographs annexed to the
Yes, they
affidavits.
met Mr. Ghosh.
Not
They
Mr.
actually
Ghosh only. Photographs of the judge being cited, and there are pictures of stampeding also.
Lordship,
Stamping on the picture.
Lordship,
This
there are
is
7 contemners, Your Lordship.
Tisha Guho's affidavit, if you look at, in CRLCP number 7. What was the occasion of showing the photograph of the judges? In every hand, there is a photograph of the judge. Must not have been eulogizing him or felicitating him. His photograph was put up. We see the next photograph, stamping. It's a bit smudged, but the contours of the photographs can be made out if compared with the previous page 10 and 11. If you see the one encircled in red, the person with the green shirt on is stamping on a photograph. If you compare with the previous page, the concerned judge's photograph, it is decipherable from that. And it's in the same, there is no case made out that any other photograph, somebody else's photo. These are the photographs which are held high.
Yes. Your Lordship, kindly have a look at the photograph. He was standing beside the photo. He was not stamping. He was not stamping on. He was just standing.
Both his feet on both sides and the photograph on the ground. Standing.
The picture, someone must have brought the picture. The picture must be lying.
Picture was lying there. He was standing.
He did not. He was standing over there. That is my defense in my.
This militates against your lip service of apology. This specious defense.
I started by saying
everybody who is frustrated will set a bad precedent like this. Then, whenever I am frustrated with you, I'll just take your photograph and throw it out and give a press statement or whatever. I'll make an agitation before the judge. See, this is the rule of law we are trying to protect, not a particular judge. It's the institution. Institution has been cliched now. Not exactly the institution, the people themselves. We don't enjoy divine power. Constitution empowers us. It's by for of the people. The people have empowered us to protect them. We are the last defense. Bastion of defense is the judiciary. So if this is done in every case where there is a frustration because adjournments have been granted as per your submissions, we are confining ourselves to yourself. This frustration, where does it end? You are stamping the photograph, you are putting, holding the photograph up of the judge. Then if this is not administration, defiance of administration of justice, obstruction, what else is? He is in season of the matter and you are holding photographs. You are trying to browbeat the judge. This is a clear attempt to browbeat the judge before whom a matter is pending so that the decision goes in your favor. How can you defend this? We can't understand. This person with his both his feet apart, he is standing almost akimbo with the judge's photographs in the middle of his 2 feet. He was not aware there was a photograph there. The previous photograph shows it's in the hands of the persons present with him. Is it credible? What was the occasion of he's standing on that photograph? It was lying on the street. It flew from the air.
What has happened should not have happened.
Why are you trying to defend this? You say that the photograph might have been lying there and he was standing it. He's not stamping.
That is why I started my submission by saying that what has happened should not be justified. There are things that should not be justified, cannot be justified.
If it cannot be justified, you go to jail then.
There is something
You cannot justify your activities, which is palpably against the institution. A matter is pending before a judge. Nothing personal, no personal allegation against him. Everything regarding that matter. So whenever a matter is before a judge, and there will be a show outside, and people will stamping on his photograph just because he's granting adjournments on the prayer of a particular party.
So the photograph reveals some of my clients or 2 or 3 of my clients who were present there, or all of them were present there. But
What did they go to do there? A picnic?
They were there. They were there. The photographs reveal that they were there. I cannot say that.
What is the reason for their being there? You have to explain yourself.
Reason being this protest that was being
Protest was
organized.
being. In that protest, you are holding up photographs, and the next scene we see is that photograph is behind the feet of somebody, and all of them. I mean, those are lying astray on the ground.
Apart from my client, I'm not justifying, but apart from my client, there were several others also who were holding the photographs.
If their names, will send them to jail also.
I am not.
We have no qualms on that.
I am not here to give anybody's name. I am here to just apologize for your lordship. What they have done wrong. Admittedly, what they have done wrong. They
See,
should not have done
every
that.
matter cannot be effaced. Every matter cannot be purged merely by giving apology. You do something of what sort? Not a criticism. Even fair criticism bordering on unfair, we can understand. We just ignore those things. That is happening every day. Even in a pawn shop, there are discussions about the judges after the live streaming. So we are not bothered with those things. But you are holding a photograph in your agitation. You're holding a photographs of a particular judge, putting it down the next scene. It's lying on the under your feet. Now, if this is not contempt, then what is? Tell us.
The
After
citation.
that, giving post facto apologies won't do. Then in every case, everybody would do that. Your frustration balanced with the rule of law, we have to take it into consideration. Frustration, what extent? Up to what extent can the frustration go?
It's a frustration, no doubt. They are victims of the circumstances.
What circumstances? And adjudication has been given by the division bench, by the single judge, division bench, affirmed up to the Supreme Court. So that is the law of the land. An adjudication that some people are tainted, some are not, whatever.
That is not related to supernumerary. That is related
This is
to,
the fallout that was linked by Mr. Banerjee with supernumerary.
no. The matter which traveled up to the Supreme Court, the Boishaki Bhattacharya matter that relates to 9, 10, 11, 12, Group C, Group D, non-teaching, teaching staff. Now, this is the supernumerary post
That was created
on 19th May 20.
The allegation is that they were in the matter. The allegation is that they were the supernumerary posts were created because that is the allegation. Mr. Banerjee was saying that he named two or three counsel, and those counsel were with these people when that happened, and subsequently assured that no, will move a matter. That is, we are entirely adopting from Mr. Bandhavate. And then this litigation was filed. Filed against what? Supernumerary post to absorb those people.
Challenging the notification.
Challenging notification. So therefore, the other advocates took a stand diametrically contrary. Therefore, this supernumerary post is a continuation of that legacy of the previous judgment.
No. Supernumerary was never under challenge before the Honorable Single Bench or the Division Bench or the Honorable.
It was not. certain appointments were, the entire appointments were set aside. After that, these supernumerary posts were created. We are not so naive.
What certain posts were created by a common order, common notification, certain posts to accommodate those persons who were creating or something in that selection.
Yes.
That was the subject matter of challenge before the honorable side. That was the fallout of a challenge. But this particular mirror, so far as upper primary issue is
That was never covered by the previous.
physical education. These persons are the wait-listed candidates for all education physical education, for whom 1600 posts need to be created for accommodating wait-listed candidates, not those persons. And that 1600 posts on being created, what we are not studying just now falling to the document. So Vanity was submitting submitted. Council was there in their meetings and their
Yes.
it is just in support of the creation of 1600 and these people will be accommodated. I have no problem. Thereafter, litigations came to be filed. And on that date, we were supposed to get the appointments, 1600 posts. Those were not accommodating 1600 wait-listed candidates in court education and physical education. Writ petition, which was the subject matter, which in fact is the
These people were not covered by the previous one in any manner. Well,
apart from a common notification whereby 1600 posts were also created by the same notification.
but that was also set aside. In the interest
that is
notification.
also- and that is to be under challenge.
Mr. Bhattacharya, whatever may have prompted this kind of conduct, be it frustration, be it mental insecurity, instability, financial insecurity, the question is whether what they have done amounts to criminal contempt of court. That is the thing we have to decide. After that, if we hold them guilty of contempt, the question of whether we accept apology or take it as a mitigating factor, that will come later. First, we will decide.
Outset, we are hearing for one of the contenders in the other matter.
So we will hear you if once Mr. Mujumdar finishes. Yes.
And there was a direction in the division bench
Mr.
in respect of supernumerary post itself, right? And that was went up to Supreme Court. Supreme Court upheld the division bench order. But so far, supernumerary investigation.
We'll hear it. We'll hear it.
Supreme Court has stayed the CBI investigation. Honorable Supreme Court has also stayed that CBI investigation.
And you continue.
Supernumerary or Group C, Group D, that is not the issue. The issue is whether my client's conduct is worth of an apology from this honorable court or not. That is the only issue. Things have happened, it should not have happened. Obviously, this is a very serious issue. But taking into consideration their plight, I would kindly request your lordship to grant them apology. And also they undertake that this will never happen in the future.
Next. No.
One of the contenders is CRLCP 7, Mr. Kumar, assisting Mr. Bondal.
Oh, you were assisting Mr. Bandhavata. I see.
But one thing is not supernumerary issue that is troubling your lot. Supernumerary issue.
Different.
9, 10, 12, the division bench judgment give some observations. Insofar as creation of supernumerary to accommodate those wrong candidates. That was put to challenge to the Honorable Supreme Court. Supreme Court by the order, that is the 17th. There are two orders. The 3rd April 2024 and the subsequent order. The 3rd April order, their lordship desired that we will hear this aspect regarding initiation of CBI inquiry separately and kept it on the following Tuesday. In fact, on the following Tuesday, for these persons, of the wait-listed candidates and everything, incidentally, we just filed an application just to be on record before the Honorable Supreme Court that this part is different from the usual selection that is gone into by the Honorable. The Honorable Supreme Court set aside the portion of the order by the CBI direction was set aside. And the main matter remained as it is. this 1600 creation, this supernumerary for this 1600 is under challenge in the writ petition, which is being heard by the honorable CP. Nothing. And in that one, on the first instance, without including these persons as parties, an interim order was made by this honorable court, restricting the effect of the creation of this supernumerary, nothing else. And an interim order was continued. That interim order continued for a substantial length of time. It is only on the intervention of a division bench that today the matter is now being proceeded with to the extent of locus standi of the petitioner and actually Mr. Bondapathy also for these persons.
Anybody else for the contempt?